legal challenges, as we have shown now. You can't hang. It's like me saying, look, if I'm arrested, I will go to jail. I don't mean that a policeman must just come and grab me, and beat me up and put me in the boot, and then I say, oh well, but you said, Mr. Mpofu, you'll gladly be arrested. Once they overstep the mark of the law, then all undertakings are off.
Mr. Mpofu, can I ask you this question, please? And it doesn't relate to the specific point you make, but yeah. It's just something I'm thinking through in characterizing the dispute and locating it within both the character of the organization and its relationship to the Constitution. It seems that we have an organization that at least constitutionally is committed to certain values, collective decision-making, internal discipline, the spirit of voluntariness.
Democratic centralism, yes.
It also seems that the organization functions at different levels where at some instances its persuasive powers are used and in some instances its coercive powers are used. And there's an interplay between the persuasive and the coercive. Okay. At some levels it functions, and preeminently so, at a political level because it's a political organization. And at other levels it must function within certain legal constraints and legal disciplines. What, if any, is the interaction between what may be conflicting paradigms, or is your sense that, well, ultimately, in the context of this case, one must simply look at the right of this individual, and if the right's been violated, vindicate the right, and the interest of the collective, as reflected both in its founding documents but also in its working methods, don't matter. And that relates in a sense to the engagement with the Integrity Commission, etc. Because there appears to be two processes that run maybe on parallel tracks. And do they ever converge, or ultimately is it the individual's interests that carry the day?
Yes, I understand the question, Justice Kolapen. I will refer you. I'm just looking for the paragraph. It's also cited in our heads. The utterances of Justice Yakub in Ramakatsa. You will find that at paragraph 50 of our heads, where it refers to, it's paragraph 16 of Ramakatsa. Justice Yakub said, and on this he was speaking for the majority, even though his was a dissenting judgment. I do not think that the Constitution, capital letter C, of the country could have contemplated political parties could act unlawfully. And if I can put in brackets, that means breaching Audi as well. On a broad purposive construction, I would hold that the right to participate in the activities of a political party, that's the right in section 19, 1B of the Constitution, confers on every political party the duty to act lawfully and in accordance with its own constitution. And here, this is the punchline. This means that our constitution, capital letter C, gives every member of every political party the right to exact compliance with the constitution of a political party by the leadership of that party. Exact compliance, right? So what it means is this. Firstly, a political party is not just a football club or some voluntary association to which I might belong with my friends. It is, as Justice Musanega called it, the veritable institution and conduit through which citizens express their political rights. And that is why this notion that we're dealing with a contract as if I'm buying shoes at the mall is laughable. You are dealing with public rights, an institution that exhibits, and Justice Cameron said this, albeit in a minority, in the case of My Vote Counts. He says that the rights there's this debate about whether, and I'm sorry to take this detour, I'm coming back to the question, Justice Kolopen. But there's the debate, Justice Kolopen, about whether PAJA applies to political parties. It's an age-old debate. It's been going on since Rabakata until now. It was referred to in the Delil case. I appeared in that case, and we tried our luck with it in Ramakata first, as you can see. What we did there in Ramakata, we pleaded out the contract, the constitution, and PAJA. And Justice Musaneke and Justice Jafta said, because they found in our favor in respect of the first two, it was not necessary to deal with the PAJA point. So they dodged that bullet that way. Then in Delil, the same thing was said. Our main attack was PAJA. And the court gave a very flattering assessment of our effort there, but it still said, no, this is the wrong one. Okay. I'm sorry. Anyway, in Delil, they said the same thing. In a case called no. I'm sorry, if the court can just bear with me. My Vote Counts, which is the one I was referring to, I think it's paragraph 38. No, that's the wrong thing. I'm sorry. This was referred to by the Constitutional Court in My Vote Counts. Firstly, the court made the point that political parties, the contracts at 129 of My Vote Counts, the following statement is made. Political parties are neither public bodies nor private. That's the culmination of the debate by Cameron J. And he does that by making an assessment of Ramakata and also of the Cape cases, let me call them that. Those Cape cases, it's a case of National Party versus Van Zyl and two others, which dealt with this PAJA point. And the point I'm simply making is the following. And I'm addressing two points at the same time. Firstly, this point which is made by the other side, that this is just a private affair. It can never be. Oh, this is the following. This is what was said in Delil, and the full bench at paragraph 29. Sorry, let me give you the citation because the one that is in our list is wrong. It's the wrong Delil case. This one is 2018, volume 3, all SA, 684 WCC. It was a full court decision of Justice Legransi, Mandami, and Shea. And they said, it will suffice to point out, as was done by the Supreme Court of Appeal in Calibre Clinical Consultants, which is another important case, by the way. If I can give you a reference to that case. It's 2010, volume 5, SA 457, SCA.
Just give me that again, Mr. Mpofu. 2010?
Yeah, 2010, my lord, bracket 5, SA 457, SCA.
Thank you.
A very important case as well in terms of the this point about Paja. It was said in the SCA said some recent decisions of the High Court in this country reflect a more expansive approach, but they are not always consistent. The question whether the conduct of a political party is susceptible to review evokes varying responses and so on. And then it quotes Marais versus the DA, Van Zyl versus National Party, Max versus the Independent Party, and so on. And in Delil, it was said that the question of whether or not the conduct of political party is susceptible to review on the grounds that it constitutes administrative action has, quote, evoked various responses. They were quoting the SCA. In this division itself, there are what appear to be conflicting judgments. See, for example, those cases that I've already read out. We may point out that in Marais, Hlophe, JP, and Van Zyl held that a decision to remove a mayor of a large city did not necessarily constitute exercise of public power or the performance of a public function. Every case had to be decided on its own terms. And this is the flattering part, which when they don't agree with you, as enticing as it may be to enter the fray and as attractive as the arguments which were advanced by the Delil's counsel might be, we are satisfied that this is not the appropriate occasion to attempt once again to decide this issue. Our reasons adopting this stance are as follows, and then it goes on. So again, the issue was dodged.
So this is the live legal proceeding now. Advocate Dalia Mpofu representing in front of a full bench 3 judges of the High Court sitting in Joburg this afternoon. And of course, Dalia Mpofu is acting for Ace Magashule. He wants Ace Magashule to be reinstated as the Secretary General of the ANC. That's the argument. You might be wondering all about the Ramakatsa case, which is being quoted. Now, this is how my memory goes. In 2012, a person called Mpho Ramakatsa was an ANC member in the Free State. He went to court and said that the Free State Provincial Conference of the ANC ahead of the 2012 Mangaung Conference had been conducted illegally because branch meetings had not been held properly. The advocate representing Mpho Ramakatsa was Dali Mpofu. Mpho Ramakatsa and Dali Mpofu won that application, and this is the case law that Dali Mpofu is quoting. Do you want to know who the case was brought against? Ace Magashule, as the Free State provincial leader of the African National Congress. In other words, if I've understood this correctly, Dalia Mpofu is quoting case law to help Ace Magashule in a case in which Ace Magashule lost. Lawyers, eh? Gotta love them. Stay with us.
not even something to think about, but I want to say I don't understand paragraph 5 of Ramakatsa to be saying that it draws a distinction between private as in political and voluntary associations. As I understand, it gives a blanket coverage of saying private or voluntary associations are also covered. And somewhere in the last sentence, I think that's where it says the contract of the members are unique. So it doesn't exclude all private, it doesn't treat the voluntary association membership as a contract as being different to any other contracts.
No. Justice Mulahle, I agree that that's what I called earlier the interplay. We have to understand there's a difference, a huge difference between, if you read Ramakatsa, between the constitution of the Houghton Club, which I might belong to, and the constitution of a political party. That's the only point I'm making. Okay, of course, Ramakatsa says that that's why Ramakatsa draws from the Jockey Club cases, because it doesn't reject the notion that voluntary associations are by their nature bound by the rules of natural justice. But it says when it comes to an entity that is ruled by the Constitution under Section 19, you have a sui generis contract because of that interplay. So it's not like any old voluntary association. It is a voluntary association which is a political party.
Okay. The other little point just before we break is, Justice, when I asked you a question about in relation to the OD and the IC, the Integrity Committee. Now, I was just rereading the last paragraph of the sentence, and I just want to make sure I understand your argument. Yeah. Your argument is basically, and it seems to come out on that last paragraph of the letter. The IC seem to be saying, we've listened to you, we think you must go back to the NEC, and it's for the NEC to then decide, to consider.
Yes, consider.
And your argument is it couldn't have, that could not amount to a hearing, no, because even on their own report, they are referring him back to the NEC, and it's for the NEC to then make the decision on the suspension. Am I? Yes. Okay.
Absolutely. And actually, to be fair, the Integrity Commission seems to be the only body that understands 2570, because they were right. Even the NEC would have to consider. There is no such thing in this world as somebody saying 2570 must be invoked. That's just a misnomer. 2570 itself is discretionary. It says even the SG may suspend you if it is in the interest of the organization. So there's no one who has any right. It doesn't matter if they are whatever their name is, or the King or the Queen of England, who can say the 2570 must be invoked, which is what happened here. So that's another reason why you can't. It's like changing the word may to must. Nobody, that's ultra virus. And unfortunately, Justice Mulahle, the Integrity Committee knew its limits. That's why it said even the NEC must consider, number one. Number two, this also shows that the real body where the Audi is supposed to happen is at the NEC, which is the point I made earlier to Justice Weiner. Thank you.
Okay, good. Shall we take a 5-minute comfort break then?
Thank you. Yes.
And when we come back, Mr. Mpofu, maybe you'll just assist us with regard to the rest of the day.
I will. I'll negotiate with Ms. Sillo.
Okay, thank you.
Advocate Dalia Mpofu, full bench in front of the, well, let me start again. Advocate Dalia Mpofu in front of a full bench of the High Court sitting in Johannesburg this afternoon, arguing in favour of lifting the suspension, the ANC suspension of the Secretary-General, Ace Magashule. It's a very complicated technical legal argument all about the Ramakatsa case that goes back to 2012, the procedure of what an orderly meeting is. In fact, there's a book called The Law of Meetings. It's literally the thickest book you've ever seen. It really is quite something. This is the kind of things that lawyers do for a living. Honestly, not for me.